Ms. Light.
Good morning. May it please the Court. My name is Therese Wright. I'm here on behalf of the Commonwealth. This case is before the Court on further appellate review, which was allowed by this Court after the Appeals Court reversed the conviction of the defendant who was convicted of the crime of rape. The Appeals Court held that the testimony of the victim's mother describing her daughter's mental limitations as it related to her trusting nature was improperly admitted character evidence, and it showed the victim's propensity to be victimized and also risked undue sympathy for the victim, and the Appeals Court reversed. The Commonwealth is here on further appellate review and suggests to this Court that the judge properly admitted the testimony of the mother with respect to the victim's limitations due to her mild mental retardation, including a description of her trusting nature, which she described for the jury. It's the Commonwealth's position that the jury was entitled to know who this victim was, and in this particular case, this was not, as it were, your typical victim. This was a young woman who was legally an adult, the mother was her legal guardian. She was intellectually slow. She was a special needs student throughout her schooling. She wasn't able to hold a job. She had suffered from a seizure disorder since she was a child, had been treated at Children's Hospital, I believe it was for 17 years. She couldn't drive, support herself. She supported herself through Social Security disability because of her mental disabilities. And during the course of the trial, the Commonwealth elicited from the mother testimony with respect to all of this history, as well as a description.
Was that elicited before or after the victim took the stand?
It was the victim took the stand first, and the mother testified after the victim took the stand. The victim.
So it was after the victim was cross-examined with respect to why she went to this house?
Yes, that's correct. And the victim did testify. One of the things that the victim testified to was that she was with her friend, she was with an acquaintance prior to going over to the defendant's home, and she had a phone conversation with the defendant, whom she did not know, and when she spoke with the defendant, he made crude sexual comments to her about wanting to have sex with her, and she explained in her testimony that she didn't want to do that, but she was just going to go over there to hang out with him and her so-called friend, this young woman named Stephanie.
Did the judge give any kind of limiting instruction on the use of this evidence?
The judge did not give a limiting instruction.
Was such a thing requested?
I don't believe so. Okay. There was an objection to the testimony. I don't believe there was a request for a limiting instruction.
Excuse me, Ms. Light.
Sure.
Was there an objection? I haven't looked at the transcript, but I've looked at the excerpts in the appeals court's opinion, and there appears to have been an objection at some point. Was there an overall objection with the defense counsel then objecting as it went along, saying none of this should come in?
Not in that manner. What happened was when the victim's mother began to describe the history of the victim, there was an objection. They went to sidebar, and the defense attorney put his objection on the record to this entire line of questioning and asked the court to accept it as a standing objection to all of the testimony so he wouldn't jump up after every question. He did object a couple of times during the testimony of the mother as it related to the specific questions about her trusting nature.
But the mother was permitted to testify, as I understand it, not just about the trusting nature of this young woman, but about specific instances of other criminal conduct.
That is correct. The mother was able to testify. She was allowed to cite two examples that she witnessed as examples of instances in which her daughter spent time with acquaintances or so-called friends who ended up, in one instance, stealing from her, in another instance, taking her outside and beating her up. And this was sometime during high school.
Let's assume for a second that it might have been permissible for the jury to know something about who this young woman is. Should there be any limitation? I mean, it's one thing to tell the jury this is a young woman who has got, limited capacity to, interact. She's got whatever medical or other conditions she has. It's quite another thing to then specify, particular examples. I mean, can't the jury? I mean, I assume that the jury saw the victim, and then you have the mother explaining that she's a special needs. child and so on.
Well, in this particular case, I would suggest that the judge limited the testimony of the mother as it related to, first of all, examples that she witnessed herself.
No, I'm not talking about whether this was, that this shouldn't have been admissible under some other ground. I mean, yes, she saw these instances, but would it not have been sufficient for the jury simply to have been told, that this is a child of, limited capacity and who could easily be misled?
Well, I would suggest that the examples that were given were illustrative of that particular trait that the victim had. It was an example of how she would sort of get herself into a pickle, so to speak, because of her naivete and her overly trusting nature, and that's what those two examples serve to illustrate. But I would suggest that what the mother did, what her testimony was really, especially with respect to the description of her trusting nature, was a description of how her physical limitations manifested themselves.
May I ask you this?
Sure.
Hypothetically, assuming you had the same situation except the person that was not limited mentally, would we allow an explanation about their trusting nature?
Well, I would say it would probably be less appropriate to do so. And the reason I say that is because what's difficult here, and in my trying to articulate this, is that there's no doubt, I think we would agree, that the victim suffered from a physical problem, at least as reflected in treatment for many years through the hospital. One of the ways in which this problem manifested itself had to do with her behavior or state of mind. So to the extent that it was commenting on something that one could deem as character evidence, I would suggest simply because the way that this disease or this condition manifested itself was in a behavioral issue, as opposed to someone who, for example, has a vision loss or hearing loss. I would suggest there would be no problem with a mother or a person with firsthand knowledge explaining that the child has a difficulty walking because of a defect of her leg, or difficulty seeing, which might explain why she didn't see a sign.
The issue in the case was consent, was it not?
It was.
And the defendant's lawyer cross-examined her somewhat aggressively, which of course was his job, or her job, on the issue of consent, did he not?
Yes, he did. And he also cross-examined her on her suggesting sort of the implausibility of the notion that she would not have agreed on the phone to have sexual intercourse with this man and yet gone over to his house.
So in your view, this opened the door for
Well,
this?
I suggest it did open the door and allowed the Commonwealth to rebut the negative inference that arose through that cross-examination. And what it served to do was to offer an explanation as to the action that the victim took in walking into this lion's den, or this hornet's nest.
Isn't the nub of the problem here that once they hear this evidence, it essentially says to the jury, she is incapable of giving consent?
I would respectfully disagree. The Commonwealth
No,
made...
it was a question. Why is it not telling the jury, in these circumstances, she is incapable of giving consent because any actions that she engages in are as a consequence of, something that is beyond her control. So she can't give consent. So if the defense is consent, she couldn't have given consent.
Well, I don't believe that that's what this allowed the jury to infer. First of all, the Commonwealth argued and made it clear to the jury that she had the capability of consenting and that she said no once she got in that rooming house. And I don't think there was any suggestion that she was incapable of consenting or so mentally deficient or retarded that she couldn't consent. I would also suggest, in terms of weighing the probative value of this evidence versus the prejudice, that this evidence could have cut both ways, because to the extent that it showed the victim as someone who was overly trusting and befriended people easily and went along with people who she didn't really know that well, it could have worked to the defendant's favor when he stated that she went along with the sexual intercourse and engaged in it willingly. The jury might have taken that evidence from the mother to to favor the defendant's argument that she acquiesced and simply consented to this.
Ms. Wright, isn't the testimony relevant because it helps to explain why the victim went to the defendant's house? It's a part of the whole picture that helps the jury to determine whether the intercourse was consensual, and the entire picture is relevant. In a way, it's something like first complaint. It just helps the jury to understand the whole situation.
Absolutely. And that's why I submit that the Commonwealth should be entitled to give the jury all of that information about what led up to her going there in the first place. The appeals court found that her motivation in going to the defendant's rooming house was, I believe they said, tangentially probative.
If that is the issue, that she goes along with it, the problem that I have is or the potential problem is with part of the questions, which is when it goes to specific criminal conduct that the mother witnessed, because it is almost like saying, if the mother testifies, look, she thinks as the first, I think it's the first part, it's at least the first part of the appeals court, she thinks of people as her friends when they're really strangers. She really can't identify. She wants to participate. By the time you go in and talk about specific criminal conduct, the impression that one is left with is that the world exploits this child, this young woman, all of the time, and that anybody who knows her knows how vulnerable she is. And it's not a question of whether she said no, but that presumably I observed her friends stealing from her, because before they left the home, I found that they stole. Now, again, that suggests that she can't say to people, don't take my, whatever they stole, money, clothes, whatever it was. Or I saw her being beaten up. She was unable to defend herself. That's a very different thing than explaining this is a child of special needs. The fact that she said, yes, I will go to the defendant's home has got nothing to do with giving consent to what he had asked her over the phone. Will you engage in sexual relations with me?
Yes, but as I stated before, I would argue that the examples given, well, there are two things that came in. One is the description by the mother of her trusting nature, and the second were the examples illustrating that trusting nature. With respect to the examples, I would again suggest that those, I don't think that the jury would have drawn such a conclusion or leapt to the conclusion that because she had gotten herself into a situation where she was the victim of a crime, she must have been the victim of a crime in this case. I think it served more to illustrate that she trusts people who...
No, because the mother's already testified in a quite moving statement. She clung on to people thinking they were her friends. She trusted them too quickly. She always called everybody her friend because she doesn't understand the difference between acquaintance. She held on to that so she could have friends. That's saying to me, why would she go, she clings to people. I really, fail to see why giving examples of where other people have engaged in criminal conduct on her.
Right, but these were other. Did the mother describe that these were other people whom the victim perceived as friends? And these are, in other words, illustrations. She thinks people are her friends when it is abundantly obvious to anybody else that they are not her friends.
Correct. She was describing situations where her so-called friends, people she didn't know that well, who she went along with.
She would call them friends when they were really anything but.
Exactly.
Yeah. Could I ask you,
Sure.
I take it that, just so I understand, when the victim was cross-examined, I think there was cross-examination about the phone call.
Correct.
With the implication that the victim's state of mind of consent began at that phone call.
Well, she testified that that the defendant had said to her, I want to F you. And her response was, no, I don't really want to do that. I'll just come over and hang out. And she was cross-examined about, so he said this to you and you still wanted to go over there, suggesting how implausible that was. And because of that, I think it was reasonable for the Commonwealth to offer an explanation as to why one might go along with her friend Stephanie to a house where someone is making these crude sexual comments to her and explain that she's not perhaps like you and me, in the
her
sense that
state
she
of
would
mind,
exercise that kind of
what
judgment.
I'm in trouble. The appeals court calls it that her state of mind at that time was tangential. I get the impression that the defendant had made her state of mind at that time very much an issue.
Oh, I absolutely would
Okay.
agree with that.
Okay.
Any other questions at this time? Just, again, I just would sort of sum up by saying that I would suggest that in this particular case, it was simply fair for the Commonwealth to be able to portray the victim in her entirety, to explain the circumstances surrounding the crime, not just what took place in the rooming house, but what took place beforehand with respect to her decision-making. And it was reasonable and probative for the mother to explain the limitations of the victim as it related to decisions she made that particular morning. The judge was in a position to weigh this evidence, weigh its potential prejudice. As I stated before, I would suggest the prejudice was not outweighed by its probative value. It did not. The mother never testified, nor was there any implication that the defendant couldn't consent or she wasn't the type of person that would engage in casual sex. It could have benefited, as I said earlier, the defendant as much as it could have benefited the Commonwealth, in that the jury might have taken her to be someone who would consent willingly because she sort of acquiesced to people who were around her. So,
excuse me, Ms. Leish.
Sure.
Was there evidence that the defendant knew her or knew her well?
he didn't know her at all.
He didn't know her
No,
at
he
all.
knew the friend, Stephanie, and that's how the phone call originated, was between Stephanie and the defendant, and then she got on the phone with the defendant. He made those statements to her, and then they went over to his home. So respectfully, I see that I'm out of time, but I would ask this Court to affirm the conviction of the defendant. If there are no other questions?
Thank you.
Thank you.
Mr. Bland?
May it please the Court, Eric Brand for Mr. Bonds. Your Honors, this case involves two kinds of character evidence that was elicited by the prosecutor from the complainant's mother. There was the mother's opinion that the complainant was an overly trusting person, and then there were two specific instances of the complainant's prior conduct that were offered to illustrate that character. We argued in the appeals court, and we argue here that both sorts of evidence were impermissible character evidence. They represented improper propensity evidence. But as to the opinion evidence, that was inadmissible for another reason, which in our view was dispositive and is argued in our brief. And that's because the evidence was not competent evidence. Under existing law, character evidence is only admissible in the form of reputation. And this, I'm referring to the mother's opinion here, that she testified to directly, that the complainant was an overly trusting person. That represents character evidence. Character evidence under existing law prior to the adjutant case is only admissible in the form of reputation. That was not the way it was offered in this case.
Is it really correct to call it character evidence when it is being linked to an underlying disability, saying this is part of what her disability involves, that her mental limitations and mental problems include this aspect? That's not normally what we think of as character.
Your Honor, that is normally the sort of subject that's presented to the jury in the form of medical evidence, expert medical testimony. For example, if in this case the complainant's longstanding seizure disorder rendered her the kind of person who was overly trusting, if it had a medical basis, as the Commonwealth asserts, there was a medical basis for this, the Commonwealth should have brought in a medical expert to testify to that.
Well, suppose there's an issue of her, her mental retardation or intellectual capabilities to understand things. Can't someone who has lived with her all her life indicate, I've seen this disability on a daily basis, and here's what it involves? She can't do this. She can't understand that. That doesn't require, seems to me, a doctor.
We didn't object to the mother setting forth specific facts about the fact that she's on SSI, the fact that she was a special needs student in school. Those are all facts within the mother's knowledge. But as to her opinion that the complainant is an overly trusting person, that, I think, is the kind, if that's improper, that's a subjective representation about the complainant's character, and if indeed there's a medical basis for it, then that should require expert testimony, because it's not within the jury's common knowledge.
Mr. Blank,
Yes, Your Honor.
here's my problem, and maybe you can help me in a way that, I asked the same question of Ms. Light. If the mother's, let's assume that the mother is competent to testify, it seems to me that what she's saying is this child, adult child, can't give consent. She can't give consent. She doesn't know. I mean, Ms. Light said, no, the jury was left to say everybody said she could give consent, but I don't understand what it is that the mother is saying except to say somebody who doesn't know this child at all. This child has a medical condition, which means that she's so trusting that even if you say something, I want to have sex with you, she is incapable of saying no. Not incapable in the sense that she can say no, but she will easily appear to give consent. And it seems to me that my concern is that the mother's testimony, however one characterizes it as character or medical expert, is really saying to the jury, I don't care what happened in that room, this child is so trusting that she will go along with anything, i.e., even if she appears to be giving consent, it's not really consent because she's so overly trusting she'll agree to anything. I mean, isn't that what the mother is saying?
I believe Your Honor is correct. It's true that the prosecutor told the jury that the Commonwealth was not claiming that the victim was capable of consent, but the mother's testimony did go in the opposite direction. And indeed, as we see it, all of the mother's testimony tended to show that the complainant had a propensity to be overly trusting, and the prosecutor took that testimony and argued in closing that that testimony showed that she had a propensity to be victimized.
Well, even if you leave aside the propensity to be victimized, what the mother testified with two examples. One, let's just take the stealing example. The mother says, these people stole from her. I know they stole from her because, something was missing. And yet she, the child, views them as friends. She didn't think there was anything wrong with that. My concern about that is, if I'm sitting on the jury, I'm saying, well, if somebody says, can we have sexual intercourse, even if it's wrong, she doesn't know it's wrong, and so she says yes, but that's not really consent. I mean, that's my problem here.
I think that the problem that you point to is a significant one, but
That wasn't the Commonwealth's argument, as you can see. That was not the Commonwealth's argument at all.
Didn't the closing link it very specifically to, this is the background against which you should interpret her reaction to this phone call. This sort of, most of us would have known, based on that phone call, we shouldn't go there.
Yes, but that has to be...
She, however, isn't like the rest of us. I mean, it seems to me the Commonwealth's, whatever potential it might have had to be misused, the Commonwealth's closing was used the evidence in a very proper way.
Well, we do not agree with that, Your Honor, because the underlying problem here is that the jury doesn't know this complainant. There's a dispute in the evidence as to whether there was the intercourse, which is conceded, took place by force or consent. It turns entirely on the credibility of the conflicting accounts of the parties. And now the mother comes in and offers her subjective opinion as to the complainant's character, which the prosecutor characterizes as a propensity to be victimized. And then she offers, the prosecutor elicits from the mother two specific instances of prior conduct which purport to illustrate the complainant's overly trusting character, in which the prosecutor characterizes as showing that she's the kind of person who would be victimized, that she has a propensity to be victimized, and all that goes directly to the key issue in dispute, the question of force or consent, because if she's the kind of person who's going to be victimized,
But again, wasn't the defendant's argument about consent began with that phone call, making the very express argument that given that the victim had gone over to his room after that phone call, that that was itself indicative that she was willing and that she was consenting.
Yes.
And the Commonwealth wanted the jury to understand that the victim's interpretation of that phone call and reaction to that phone call would be affected by her disabilities, her overly trusting nature, and that she would do things that the rest of us wouldn't do. They were trying to rebut, if you were, the inference that the defense was trying to raise about doesn't her reaction to this phone call tell you that she's consenting?
Yes, Your Honor.
The phone call and how she would react to that call has now has been made by the defense.
Yes,
An
but the
important
Commonwealth
issue in the
can only respond to that argument by proper evidence that's competent, relevant, not propensity evidence. And this goes to the question of whether the Commonwealth raised in its brief about whether the defendant opened the door to this evidence. We argue this point in our brief. The defendant did not open the door to this evidence.
Was there testimony in the case that the victim had said, no, I don't want to have sexual intercourse?
Yeah.
As the phone call is recited, she says that she said, no, I don't want to do that.
Okay.
But I'm going over there anyway.
Okay. Now, was there, with respect to the two instances that the mother gave, as you know, the prior instances of her daughters being victimized, was there any resistance or statement of acknowledgement by the victim that she didn't want this property to be taken from her, that she said, no, don't take the property?
That was not discussed in the complainant's testimony at all. It only arose in the mother's testimony. So there was no. So the answer is no. There was no discussion of the complainant's.
So why don't the circumstances in this case seem to suggest that the Commonwealth use of this evidence really was limited to why she went over there in the first place, because they were also saying that she said, no, I don't want to have sexual intercourse. She had said no to the sexual intercourse, but she said, yes, well, I'll go over there.
It is offered for that purpose, but the Commonwealth can only argue that purpose based on competent and relevant evidence. And we say this was not competent and it was not relevant. And as to the question of whether the defendant opened the door, the Commonwealth says that the defendant opened the door to the propensity evidence by presenting evidence about the phone call with the defendant in which he allegedly said he wanted to have sex with the complainant, and then her subsequent decision immediately after the phone call to go over to the defendant's house.
It seems to me that you can't have it both ways as to her statement that she said no. I mean, the Commonwealth is arguing that she said no to the sexual intercourse. And therefore, the only reason they were using this propensity evidence was to explain why she went over there in the first place. They couldn't use it for both purposes.
That is the only reason they were offering it, but that doesn't make it permissible. That doesn't mean that they get to offer propensity evidence for that purpose.
Wasn't the implication that she was going over there, but she wasn't going over there alone. She was going over there with Stephanie.
Yes.
It seems to me the implication is not that she trusted the defendant, but that she trusted Stephanie, whom she had already identified as a, quote, friend. That's the parallel, if you will, that's being drawn, that she trusted Stephanie and that it was Stephanie who didn't protect her, didn't take care of her, didn't look out for her.
Well, that's the inference that the Commonwealth is seeking to draw based on evidence that the complainant has a propensity to be victimized.
I mean, the
propensity to be trusting.
Overly trusting, and thereby
she was overly
victimized.
trusting in Stephanie, and
there's no
thought that Stephanie accompanying her was all that she needed to make her perfectly safe to go to the defendant's house.
But this evidence about the phone call and her subsequent decision to go over to the defendant's house, that was not elicited by the defendant. That came in the first place on the prosecutor's direct examination of the complainant. Defense counsel did cover the same ground in cross-examination.
Right. And the clear implication of the defense was, having heard this information on the phone call, she wouldn't have gone over there unless it meant she was consenting to it.
But how could
that was ultimately argued quite explicitly by the defense, was it not?
It was. That was the weakest point in the Commonwealth's case, as we say in our brief.
So it's not tangential.
Did she say no to the sexual intercourse as it was happening?
On her testimony, she did.
Okay.
On the defendant's testimony.
Let me just ask, and again, there's a lot of evidence in here, and it seems to me that the appeals court said two things. One is, it's not the propensity to be trusting In other words, the propensity to be trusting, to trust Stephanie, it seems to me, that may be reasonable. It's the propensity to be victimized. In other words, there's testimony from the mother, which I read a little bit, but that she's a trusting person, so she might have trusted Stephanie. I mean, that may have explained the phone call, why she went there. But the appeals court focuses on the propensity to be victimized, which is a problem, but then...
Which the prosecutor argues specifically.
No, I understand. And then these are very, in the appeals court's words, and I have to say, when you read the testimony of the mother, they are very graphic examples of where this child has been mistreated and abused. This is not, I mean, the mother partly says, look, I know of one case where 3 high school girls came to my home who I'd never seen before and asked her to go down to a certain girl's house in the same street where we lived, and she went. You know, she trusts people that she hasn't met before, but they didn't do anything to her. It's the examples of what terrible things were done to this child.
Exactly.
That in a sense only strengthens that this is being used to suggest that she has a propensity to be victimized and that you therefore...
Yes, Your Honor. Yes.
So you're saying that the Commonwealth, in its closing, went beyond what any legitimate use that they could have made of the evidence itself?
I don't think there was any legitimate. I don't think the evidence was admissible. I don't think there was any legitimate use they could have made of this evidence. And I think the prosecutor, in arguing that she was victimized, that the evidence showed that she was victimized, merely realized the purpose for which they elicited the evidence in the first place.
On a slightly different subject, did you object on the basis that the mother wasn't qualified to say that the daughter had a naive and trusting nature, and that it was the result of her mental condition?
There was the objection was the standing objection made at the outset of this testimony was based on relevance.
But it wasn't based on qualification.
It was not based on
But you argue that in your brief.
We argue that in our brief.
Okay,
Yes, Your Honor.
thank you.
I'll just conclude by saying that the most unfair part of the Commonwealth's use of this evidence was that, as to the prior conduct evidence, was that prior conduct evidence showed virtually nothing about the complainant's own conduct. I mean, typically, when you're talking about inferring, beginning with prior conduct and inferring conduct in conformity, you're talking about at least the same person's conduct.
That's the testimony of the mother. She says these total strangers come over and this child goes with them. That's the child, but the examples of people beating up on her and...
Yes, that's the prior conduct. Well, what do those prior conduct examples show about the complainant's conduct? Well, in the first instance, all they actually show is that she was present in her home with friends. The point of that testimony is not conduct of the complainant, it's the conduct of the other people in the incident who stole.
No, I think it's illustrative. She will think people are friends even when I can demonstrate conclusively they are not.
Yes, but the Commonwealth is trying to get the jury to infer from the conduct of these third parties, to infer from the conduct of the third parties that she has a propensity to be overly trusting, that she's the kind of person who's overly trusting, and that therefore she was victimized in the present case. So really, the Commonwealth is reasoning from conduct of other parties for whom the defendant is not responsible to the situation in this case where to make the argument that she was victimized by the defendant, meaning that the intercourse occurred by force and not by consent.
Did the prosecutor stress in closing that the victim had said no?
I can't answer that question in terms, but I'm sure that was the point of his argument. Yes, Your Honor. So we say, Your Honors, that the appeals court's decision was correct, and we ask that the convictions be reversed.
Thank you, Mr. Bland.